Welcome back, everyone. So, affording litigation in a lawyer like you is very expensive because we are spending a lot of time, money, and energy to become solicitors. So it should be a bit expensive, but on the other side, you need to think about poor people like me who can't afford litigations. So that's what is an interesting topic we'll try to understand today. And we are tackling it. It is one of the most practical and, dare I say, financially sobering part of civil litigation: how to pay for it. And this is one of the questions that everyone asks, even they are aggrieved, their rights are taken, and they are left without solicitors. They cannot pay. And litigation, of course, like, it's very complex, even for us, like, who have already done LLB and understand law a bit. So now the rules for procedure are all well and good, but unless someone can actually afford to get into court, justice remains a rather expensive dream, even in the United Kingdom. So in this session, we will look at how litigation is funded in England and Wales. Remember, under the Solicitor Regulation Authority Code, we must give client clear, honest, and comprehensive advice on funding options. The funding choices does not like the funding choice does not just affect money, it shapes strategy, risk appetite, and even settlement timing. So as we go, though this chapter keep this in mind: in litigation, cost is not an afterthought. It is engine under the bonnet. That's what we need to check before we start the litigation car. So let's start with two extremes of funding spectrums: private payment and legal aid. With private funding, the client foots the bill as we go. Hourly rates, disbursement, expert reports, all of it. It offers control, transparency, and the freedom to choose your own solicitor. But as many clients discover, it can make the wallet tremble. Now, legal aid. Once upon a time, this was the safety net for those who could not afford justice. Today, it is more of a small blanket with holes in it. The legal aid agency only covers limited categories. Think housing, for example, domestic violence, child welfare, commercial or contractual dispute. Not a chance. You can't get it. So when advising, always explain that eligibility depends on both means and merit. Even if a client qualifies financially, the case must have a reasonable prospect of success. So signpost to students, like, you need to signpost to your client, make sure that you can distinguish between where you will get the funding and where you will not, so you should also make sure that you can distinguish between means test eligibility and merit test. So that's something which is examined in exam, and we'll talk about it. So now, moving along, the trade union funding. So there are funding people get from trade unions, becoming a member of them, or as I like to call it, collective strength in numbers. People just pool their fundings, and afterward this funding helps them in civil litigation. If a client is a member of trade union or professional association, they might already have legal cover through it. These are common in employment dispute. The catch: they often insist that the client uses the union panel solicitors. So as solicitors, even if it means losing the case to another firm, we must still advise client honestly about this option. Professional ethics before profit always. Like, someone comes to you and they are a member of trade union, don't offer your service in the first go. Signpost them that you got something that can help you and you can save money. So next up, before the even insurance, we got it, like, many people, they got it. For example, I was looking for car insurance policies, so there was a button that you click, you get, like, legal cover as well, but the premium goes high. This is one of those hidden gems. Many people have it without realizing. It is often bundled with car, home, or business policies. Always tell client to check their policy documents before instructing solicitors privately or before just parting their money off. But beware, these policies can limit the choice of lawyer and may only cover own side cost, not the opponent cost. So in SQE terms, in SQE exam terms, think coverage and control when answering related questions once there are, like, what you need to advise to your client. So, and now the glamorous sibling of BTE before, so that is after event insurance, like, that was before event and it is after event. Imagine losing a case and even having to pay your opponent costs. That is where ATE steps in. It protects against the nightmare, although it is very costly sometimes. The type of insurance is usually taken out once litigation becomes likely. It is especially common when paired with conditional fee agreement, which we will discuss shortly. We'll just explain it. What is conditional fee? One key point, premiums are usually non-recoverable from the opponent, except in a few rare cases like defamation or clinical negligence. So the client bears the cost even if they win. Many after event insurances policies are deferred premium. You only pay if you win. Sounds great, but the insurer will charge more for taking on that risk. It's very high sometimes. That is always a catch. It is litigation after all, of course, like, you need to pay. And the next thing is conditional fee agreement, and those are tested in SQE. The famous conditional fee agreement, better known as no win no fee. Maybe you received calls like, have you ever been in an accident and these kind of things. This one always gets attention because it sounds like a free lunch until you read the terms. So be careful once you receive a call. Under CFA, the solicitor only gets paid if the case succeeds. If it does, the solicitor receives the normal base cost plus a success fee, which can be up to 100% of the base amount. They take away everything, so be careful and read the terms. But and this is important for SQE since LASPO, that is in LASPO 2012, success fee are no longer recoverable from the other side. Except in a few special areas, they now come out of the client damages. For personal injury cases, there is a 25% cap on the success fee relating to pain, suffering, and loss of amenity. This prevents clients from being left with crumbs after victory. So be careful with it. So there are also discounted CFAs where the client pays something along the way and more if they win. A sort of pay now, pay more later model, kind of like, So in exam, if you see a question about recoverability of success fee, the answer will almost always hinge on whether LASPO 2012 applies. So LASPO, I was talking about it, like, so I will give you the abbreviation. That is Legal Aid, Sentencing and Punishment of an Offender Act. Like, that's a long thing. So that's why I just used the word, like, instead of giving you all abbreviation. So keep in mind whenever we use LASPO, it is Legal Aid, Sentencing and Punishment of Offender Act 2012. So yeah, so that deals with legal aid briefly in United Kingdom. So another thing that we need to look at is damages based agreement, and that is like, think of these as solicitors' version of contingency fee. The solicitor gets a percentage of the damages if the case is successful. The key percentage to memorize, and that is tested in exam. So you can get 25% in cases of personal injury, 35% it is capped for employment claims, 50% for everything else. Like, If the client loses, the solicitor gets nothing. So you must believe in your client case like a football fan in a penalty shootout. Like sometime it works and sometime it does not. Solicitors are quite good at reading files and then accepting case under damages based agreement. Now, on the third party on commercial litigation funding, this is where investor bankroll the case in exchange for a share of winning fee. It is a booming market in high value commercial claims, but beware, RVCAT, this case shook the funding world. The Supreme Court held that funders taking a percentage of damages must comply with the DPA regulation. Many existing funding agreements suddenly became unenforceable. So for the SQE, remember the DPA compliance is now essential for any funding agreement tied to damages recovery. So things have changed since 2023. So beware of it in your SQE exam as well. So time to bring in all together in our SQE focus. So first, be absolutely clear on differences between CFA, DPA, ATE, and BTE. The examiner loved to mix these up in MCQs. Do not let them catch you out. So be careful about all of them, and I've seen questions about it. Second, remember the LASPO 2012 reforms. They are the diving line between old and new funding rules. Third, legal aid is the rarest of beasts in civil litigation, so treat it as the exception rather than rule. So it is not like golden era of British Empire where everyone gets help from the government. We are in new normal where state does not have that much money, so it becomes legal aid becomes exception. So you need to understand the difference between mean test and all, like mean and merit test that we talked about. So mean is the money earned and the merit is does it work for this case or not. So that's what you need to look at. And finally, always consider the solicitor's duty to advise on all available funding options, even those not financially advantageous to your firm. Like sometimes they are member of like union, so just point them to the right direction. Don't look for money at first. But look for money, of course. So common pitfall that we got confusing ATE with BTE. After event insurance with before event insurance and all, assuming third party funders will automatically cover adverse cost. They will not. Forgetting the success fee and ATE premium are usually non-recoverable. And there you have it. Funding litigation is in a nutshell, or as clients might call it, the bit that makes them sweat. Thank you very much for listening to us, and hopefully it makes sense. Our notes can further reinforce your learning. Thank you. Have a good day. Ta-da!